This week on the Communicators, Virginia Representative Bob Goodlatte talks about telecommunications issues, including privacy, piracy, and spectrum. Congressman Goodlatte chairs a subcommittee on competition in the Internet, and he heads the Congressional Internet Caucus.
Well, when it comes to telecommunications and policy, Representative Bob Goodlatte, a Republican of Virginia, wears two hats. First, he is chairman of the Judiciary Subcommittee on Intellectual Property, Competition, and the Internet, and he is co-chair of the Congressional Internet Caucus. He is our guest this week on the Communicators. Representative Goodlatte, let's start with something that your committee worked on earlier this year, the piracy issue. SOPA, PIPA, number one, is there any chance of this legislation coming back up this year? And if not, do you see it coming back up next year?
Well, SOPA and PIPA are dead. I think that that's pretty clear that the effort that was undertaken there ran into a lot of controversy, a lot of miscommunications, and so I think those bills are not coming back again this year or any year for that matter. The issue, however, is very much still a problem, and that is various types of crime on the Internet, the theft not only of movies and music and software, but really putting up websites that look identical to the company's website and then selling their product, tangible goods. You know, in my district I have Rosetta Stone, and they have the language programs knocked off. You can get a knockoff copy, looks just like the yellow box that they sell their languages in and so on, except it's incomplete, doesn't have everything in it that you would get if you bought it from the company. The consumer doesn't know that and doesn't find that out until they actually try to use it, try to get updates for it and that sort of thing. So that's a problem. We even had the company that makes Vibram shoes, you know, the shoes with little toes in them, on our committee testifying about the fact that they have an identical website, or more than one, that looks just like their website. You go on there, you don't know, you order what you think is the original product, and you get a cheap knockoff shipped to you from China, and that kind of problem needs to be addressed. So there's generally consensus amongst people on all sides of the issue that there is a problem and the problem needs to be addressed. But obviously, there's not consensus about how to go about doing that. So I remember back to when Henry Hyde was chairman of the Judiciary Committee and we had the Digital Millennium Copyright Act. And the big issue there between the tech companies and the content companies, the movies and music companies and so on, was under what circumstances could they get the cooperation of companies that are providing services online. The focus really then was on the internet service providers, AOL and the telephone companies and the cable companies. What kind of circumstances could you get them to take down content that was illegally posted or given away on the internet? And I was put in a room with representatives of a great many organizations, everything from universities and libraries to movie studios to Microsoft and other tech companies. Some of the companies that are at the forefront today didn't even exist back then, but we worked out the notice and takedown provisions and the safe harbor provisions of the Digital Millennium Copyright Act, and they worked well for quite a while, and they still work under certain appropriate circumstances, and no one is calling for the elimination of that safe harbor and that notice and takedown provision. But as the internet has become faster and as the problem has become more severe and the sophistication of the criminals has become greater, it's clear that new tools need to be provided to the companies, to law enforcement, and so on. Now, most of those, in my opinion, will come from business deals, the use of technology, various types of cooperative agreements, and we're seeing lots of that taking place all the time. It'll also come in part from lawsuits that have taken place and decisions coming down from lawsuits involving Viacom. Rosetta Stone is another one that's had a lawsuit recently decided by a higher court in their favor and sent back to the lower court. I think all of this is going to ultimately lead to a greater focus on solving this problem in a more cooperative fashion, and I would harken back to what was done by Henry Hyde, and that is bring the parties together, everything from the Electronic Frontier Foundation to movie studios and recording industry and so on, and put them in a room together and say, let's come up with the new ways to solve this problem. Hopefully most of those are not legislative, because legislation always is very slow moving, and this technology is changing and the business models are changing far more rapidly. But nonetheless, if there are some legislative solutions coming forward in the future, I would expect they would come out of that type of a discussion, and we would move forward then hopefully with a lot more consensus than we had earlier this year.
Would you be an active participant, particularly if the Republicans retain control of the House?
Well, as the chairman of the Intellectual Property Subcommittee, I view it as something that is very, very important for job creation and for maintaining jobs that we already have in the United States, and for protecting those provisions in the Constitution that respect private property rights, that recognize the rights of artists and inventors to have protection of their creative works. So yes, we definitely want to make sure we solve this problem. And my view is the tech companies that develop this fantastic new ways that their consumers can utilize all of the fantastic creations of the creative community, they need each other. The creative community needs the new applications so that they can get their products to consumers in the way consumers want to have them, and the tech companies need the creative works to make their products more attractive because they actually have things on them that people want to look at, to use, to play with, and so on.
Joining us as well is Juliana Grunwald of the National Journal. She is our guest reporter this week.
So if you do take up this broader issue, maybe not necessarily SOPA, as you said, what do you think supporters need to do differently this time to avoid the fate that met SOPA, which was derailed in January after an unprecedented protest by the internet community?
Well, first of all, I think they need to look at it from the standpoint of working with people who are concerned about various aspects of that legislation to, A, make it perfectly clear where there are actual differences and where there is misunderstandings, and correct those. But then secondly, and I think most importantly, is to sit down and work out the solutions. And most of those solutions are technological. They're related to new business deals. They're related to things that would enable people who want to have their valuable works shared with consumers with new technological devices in ways that still allow them to recover the cost of creating these works. And in order to do that, I think you have to have greater cooperation, greater discussions than have taken place thus far. So we would certainly be looking to promote that.
So instead of bringing in different stakeholders, which I know you did before SOPA was introduced, bring all the stakeholders together and try to sit down and find areas of agreement? Is that what you're envisioning?
Ultimately, that would be something that would be likely to take place. But in the meantime, as I say, there's lots of other things that are happening in this area to try to solve this problem, and we should let those play out as much as possible as well. Like I said, lawsuits that assign responsibility to one party or the other to protect works that are utilized on different devices, new technologies that are being deployed almost every day. I'm visited or told about some new startup company that has worked on something that would help to protect intellectual property in various spaces that people would want to utilize the technology and enjoy those great works.
Now, another issue that I know isn't directly in judiciary's jurisdiction is the issue of privacy. The president has proposed a privacy bill of rights to give consumers greater baseline privacy protections, and it is called on Congress to pass this privacy bill of rights. Where do you stand on that proposal?
Well, first of all, we take a very keen interest in this in the Judiciary Committee because, again, there are criminal statutes, there are other matters that do give the Judiciary Committee a great deal of interest in protecting people's privacy. But what we have recognized is that every different company offering services has a different view of what kind of services they'd like to offer and what information it's necessary for them to have to offer those services. And every consumer has a different point of view about what level of others having access to and using information about their behavior, their lives, if you will. And as a result, it seems to me that to try to write standards that would allow for government agencies to regulate strongly in this area, which is the direction they've attempted to go in Europe, and I don't think with great success, would have tremendous harm to the internet and the ability of people to benefit from what it really does, which is to pull together great amounts of information and put that information at the will of consumers to say, yes, I want to do this, no, I don't want to do that. In order to do that, companies have to know something about what your behavior is. And it's not new to the internet, it's just the internet is a more sophisticated way of doing it. If you went into a men's clothing store, Peter, and the salesman remembered that you liked a particular brand of suit, a particular type of suit, and then he wrote that down or just remembered it in his head, and 6 months later called you up and said, hey, we've got a sale on the suits that you like, you might say, oh, you know what, I don't want you to be bothering me about that, and he probably wouldn't call you again. On the other hand, you might very much appreciate knowing that the kind of suit you like is on sale. So that's not too much different than what a lot of information is made available to you on the internet. If Amazon.com remembers that you bought a biography, and the next time you go on their site, it pops up, the first thing comes up is, welcome back, Peter. We know you like biographies. We have a new biography about Ben Franklin. I'm not offended by that. We have specific laws already on the books protecting highly sensitive areas like medical records and financial information and children more broadly, and we certainly need to enforce those laws. But I think for broader information about one's commercial activities and other activities, I think the important thing is for companies that you do business with on the internet to make their policies transparent, to have a very consistent policy, and then to rely upon some of the traditional enforcement mechanisms such as breach of contract or false advertising. And you have areas where the Federal Trade Commission could step in and say, look, you set forth this policy, you didn't abide by it, and so therefore there's some consequences. That's far better than having the federal government step in and write in greater detail and then turn over to agencies the power to write regulations to implement those particular details and wind up with a massive regulation of the internet that would harm its basic purpose, which is to share information. The consumer should have the end ability to say, I don't want my information shared in particular ways. So the better the transparency and the better the controls made available to the consumer, I think the better the business model, and we ought to really let these companies compete with each other once they meet those transparency and control guidelines. So I'm an opt-out kind of person rather than an opt-in where you have to go and get somebody's permission before you can tell them about something they'd like to know about. I'd rather they say, no, don't bother me.
Well, Representative Goodlatte, you talked about the freedom of the internet, and FCC Commissioner Robert McDowell earlier this year wrote an op-ed in the Wall Street Journal about UN control, or the UN treaty regarding the internet and regulation of it. And he writes, any attempts to expand intergovernmental powers over the internet, no matter how incremental or seemingly innocuous, should be turned back.
Well, obviously, you have criminal activity that takes place on the internet, and you need to have laws that apply in that space just like you do in the rest of our lives. Most of the laws that we have on our books that prohibit theft and other criminal activity already applies to that activity, whether you do it in a store on the street or whether you do it on the internet. And so throwing the book at the bad guys is something that I think really we have to do no matter where criminal activity takes place. But I very much agree with him that when it comes to attempting to regulate aspects of the internet as opposed to simply punishing those who break the laws that exist on the books, is a slippery slope that we should avoid. And this privacy area is one example of that. And what really concerns me is that because of the nature of the internet reaching across international boundaries and really getting into any part of the world, it's almost a natural thing for people at the United Nations and others who believe in greater international law to say, well, we should have the UN set up an agency to regulate the internet. I think that's a horrible idea, and we should resist it at all costs. So I very much agree with him on that point. And you know what? There are very active forces at work trying to do that. We've set up an international independent entity. It's really a private entity called ICANN, the Internet Corporation for Assigned Names and Numbers, which has some supervision from the U.S. Department of Commerce to just, sort of as a traffic cop to make sure that this all works in the very complex world of Internet communications. But there are many who are not satisfied with that and want the UN to take over that responsibility. The United States and other countries that believe in the economic engine that is the Internet and the communications and freedom that come from the Internet should resist that very, very strongly. We do not want countries like China and Iran and many, many others who do not have anything close to the First Amendment that we have in our Constitution. We do not want them to be setting the standards for how their citizens or anyone else's citizens communicate internationally on the Internet.
Well, as you know, ICANN has launched a controversial program. They launched it at the beginning of this year that allows for the introduction of an unlimited number of new top-level domain names that would compete with .com and .net. And 2,000 applications have been submitted to ICANN, so seemingly there could be nearly 2,000 new domain names if they all go through. Do you have concern that if they don't do that program right, which, as you know, is very controversial, that it could be an excuse by the International Telecommunication Union or some other UN body or international group to press to take over some of these functions and get their foot in the door on Internet regulation?
Well, I very much have that concern. And in fact, I've been outspoken for a few years now about this whole plan to offer, and it extends to several levels. 2,000 domain names, each spending a couple of $100,000. That's a lot of money coming into an agency for which there's really, in my opinion, no identifiable need to have anywhere close to those kinds of revenues. But even a greater concern is what this does for companies attempting to do business on the Internet and individuals attempting to do business on the Internet, attempting to protect their creative works, attempting to protect their trademarks, their trade names, and so on. And so it's a major test for ICANN to do this in a responsible way that does not open themselves up to the claims that they have mismanaged this and therefore someone else, particularly the United Nations or some other international body, coming in and saying we're going to take over the responsibility for regulation of this critical element of the Internet, and that is, what your address is, how you reach other people, how you communicate with them, how they find you. That is the core of how the Internet operates, and we should not, again, want to see an international organization that could find that very slippery slope that the FCC commissioner identified being the basis for regulating not just how the Internet operates, but what kind of content is available on it and how people can express themselves. So it's a very grave concern, and they've already had some mess-ups with the initial launch of this. So we've encouraged the Department of Commerce here in the United States to look at this very, very closely, to communicate with their concerns to them. I've held hearings on this issue. I participated in various symposiums and so on, all the time expressing the concern that they're biting off more than they can chew, and that they are risking their own autonomy by going pell-mell into issuing hundreds or even thousands of new top-level domain names without having a good strategic plan for carrying it out and a good reason for doing it in the first place. Yes, over time you have to add more top-level domain names. Why do we have to open it up to this kind of excessive use that complicates the problem for just about anybody using the Internet?
Now, you mentioned that you held a hearing, and as you well know, the current chairman of the full Judiciary Committee, Lamar Smith, is term limited, so he will not be able to be chairman next year if Republicans maintain control of the House. You're one of the more senior members on that committee. Do you plan on seeking the chairmanship if next Congress?
Well, it'd be a great honor to serve as chairman of the House Judiciary Committee, and we will leave that to the Republican steering committee and a process that'll take place later on this year. And in the meantime, focus on doing what's critical for that, and that is to make sure that the Republicans maintain the majority in the Congress. So I'm working on my own reelection and helping to elect other Republicans around the country, and we'll focus on that opportunity later on. But certainly the Judiciary Committee is one of the most important committees in the Congress, and to serve as chairman of it would be a great opportunity for anyone.
So I take it it's a yes that you have an interest in it if the opportunity presents itself?
It certainly is something that at the appropriate time we would be communicating our interest at that time.
Well, Representative Goodlatte, as you know, this week there was a hearing on the future of video, the future of television, the Energy and Commerce Committee. But a lot of the discussion was about the difference between internet video and television and broadcast and et cetera, et cetera. Given the broad scope of the discussion and the change in technology in the last 10, 15 years, would you, in the next Congress, be supportive of or work on a major rewrite or a comprehensive rewrite of the 1996 Telecom Act?
Well, I think we're going to be taking up aspects of that with various pieces of legislation that will come before the Judiciary Committee and the Energy and Commerce Committee, the Satellite Home Viewer Act, the licensing fees that relate to various types of broadcast of music and so on. All of these need to be reviewed, and then you draw your conclusions after you conduct those reviews as to whether there are legislative changes that are needed. Since these laws need to be revised, we're going to hear from a lot of different viewpoints about changes they'd like to see or changes they would not like to see. And as we move forward with that, we'll certainly be looking at that. Generally speaking, because of the dramatic change in technology and the change in the multitude of different ways that consumers get access to various types of content that's available on all of those different platforms that you mentioned, you wind up having some changes. But whether a major rewrite of the entire 1996 Telecom Act is called for or not, I would want to reserve judgment on that. The fact of the matter is, the law was written back then in contemplation of the fact that we were going to see lots of new ways in which people would communicate with each other. And laws, as I said earlier, are slower moving in their evolution than the technology itself is, and the great consumer products that utilize the technology. So the fact of the matter is, we have to constantly look at that, and adjustments do have to be made, but how radical those adjustments might be, I think you have to leave to a fuller exposition of the issues after we get a closer look at them.
Well, for future Communicators, we interviewed Walt Mossberg of the Wall Street Journal, and that's one of the things that he raised. He said Congress is often 10 years behind technology, 5 years behind technology. Is that a bad thing?
Well, I don't think it's a particularly bad thing, because what it does is it limits the ability of Congress to step in and regulate in these areas. If you're a big believer in regulation, then you're always frustrated that the regulations aren't staying ahead of all these great new ideas and great new technologies that are being deployed. But I think the new technologies that are being deployed and the content that's being created and the new ways that consumers can utilize that content are occurring because there is not a lot of regulation of the internet, and we should be striving to keep it that way. Again, that's not to say that there aren't areas where people abuse the law and in some instances break the law, and those people should have the book thrown at them. But creative people who are trying to come up with new startup businesses and new products to offer on the internet, they should be encouraged, and they should not be worried about the next round of new regulations snuffing out their great idea. Instead, they should be saying, look, we know there are certain criminal laws on the books and other laws, antitrust laws, and so on, and we've got to stay clear of those. But if we do that, then we should know that we have the opportunity to succeed or fail based upon the greatness of our ideas and not based upon what a government bureaucrat thinks is a good idea. And that's really, in my opinion, a good thing, that we limit the ability of the FCC and other government agencies to regulate the internet.
Juliana Grunwald.
You mentioned the 1996 Telecom Act, and there's some concern that a industry transaction that's seeking regulatory approval right now between Verizon and a group of cable companies, there's some concern that if that deal goes through as proposed, that it would undermine one of the chief goals of the 96 Telecom Act, which is all the different companies will compete against each other. The cable companies will offer internet, phone, video, and so will the phone companies. And there's concern that a cross-marketing agreement that Verizon and the cable companies have proposed, that could undermine that. That critics say that basically they're agreeing not to compete against each other. Do you have concerns about this transaction? And also, there's been calls for the House to hold hearings on it. Do you plan any hearings?
At this point, we've not called for hearings, but we do always have a concern when there may be anti-competitive agreements reached by various combinations of companies, because those are not in the best interest of the consumer, who I think benefits when there is the maximum amount of competition. So that is clearly something that is the jurisdiction of the Antitrust Subcommittee of the Judiciary Committee, which I chair, and like a lot of other business arrangements which we have held hearings on in the past year, the ATT Deutsche Telekom merger. We've held hearings on some other business areas unrelated to the internet, and we certainly are always open-minded and looking at each one of these things to determine whether or not we think it's appropriate to ask some of the tough questions and shine a spotlight on these areas. And we also are always encouraging the Justice Department and the Federal Trade Commission, which share antitrust jurisdiction, to make sure that they are looking. That doesn't mean they should always act, because sometimes you can create more benefits to consumers and more competition when companies are able to band together. But you also can see circumstances where too many companies with too much market power band together to control prices and limit consumers' access to various things that they would like to have access to. And that's why our antitrust laws exist, and why I'm a supporter of using them to promote competition.
And we have time for one more question. Juliana Grunwald.
So, but do you have any specific concerns with this particular transaction?
Not yet, but we are always interested in looking at various business proposals.
And do we have time for one?
Go ahead.
Finally, a few weeks ago, the Energy and Commerce Committee had a hearing on the future of audio, and there was a lot of talk about the royalty payments paid by online radio stations, and whether radio or terrestrial radio stations should also pay royalties to performers. That's an issue you guys addressed a few years ago, but it didn't go anywhere. Is that something you see the committee going back to? Is that a concern for you?
Well, it's definitely a concern for the committee, because we have a number of different platforms on which music is made available to consumers. Broadcast is one of those, but then available over the internet and available in various other formats, and each one seems to have a different standard and a different rate. So there is a fairness issue that needs to be examined and addressed here. And then, of course, you have the performers who have the rights to their work, saying that in some instances we're paid a royalty, and in some instances we're not. And so, again, that has to be addressed as well. When you do that, you have to take into account the evolution of the broadcast industry and how it's changing, and how it merges and diverges from other ways that people are receiving this same kind of content. So it's an extraordinarily complicated issue, but it's one that I think we do need to tackle and attempt to address the issue of what is fair in this process.
And that also leads into the fact that your committee is looking at the internet sales tax, particularly if it comes to downloading music, correct?
Well, the internet sales tax relates to our jurisdiction because it relates to states collecting tax across state lines, and that is another whole jurisdictional area for the House Judiciary. Basically, state compacts and state relations with other states is our jurisdiction. So that's an issue that affects transactions on the internet. We also have the issue of states in tight economic times attempting to collect not just sales taxes, but other types of taxes from businesses that are briefly in their state. And it's not just necessarily things that occur on the internet. It could be driving a certain number of trucks through your state. And if you pass 6 or 7 trucks, then they say, well, you got to file a corporate income tax return or business activity tax return. So I have legislation that attempts to create a bright line test so we can promote interstate commerce, promote competition, encourage small businesses that are reluctant to do business in other states because of the complexity of when they might get hit by another state's contact. We ought to be able to tell them, this is the line. If you want to do business, you cross that line. Other states can tax you. If you don't cross that line, you don't. And I think that would benefit not only businesses expanding and creating jobs, but it also would help states that waste a lot of resources trying to get businesses to dance on the head of the pin, because they would know under what circumstances they could then tax an entity coming into their state, which would be a fairly de minimis contact. A certain number of days doing business in the state and certain other contacts would allow them to impose these taxes. But if it's less than that, then we say it's de minimis and businesses shouldn't have to worry about that. If you go to a trade show in a state and set up your booth, don't even sell anything, is that sufficient contact with a state to allow them to require you to file a corporate income tax return? I would argue definitely not. We should be promoting people going to trade shows and sharing their ideas and so on. But if you go into that state and set up a business and operate it there for a period of time, certainly the state should be able to impose their state and local taxes on that business.
And we are out of time. Representative Bob Goodlatte is chair of the Judiciary Subcommittee on Intellectual Property, Competition, and the Internet. He is also co-chair of the Congressional Internet Caucus, and Juliana Grunwald is a tech and telecom staff writer for the National Journal.